Now, many people would have just been happy to leave and not follow up. Thankfully, Mr. Sakuna was not one of them. On July 25, 2019, Sakuna filed a complaint in the United States District Court for the District of Connecticut. He principally alleged that Andruski's actions deprived him of his Fourth Amendment right to be free from unreasonable and warrantless arrest and/or detention, and warrantless and unreasonable search and seizure of his person, vehicle, and effects, and sought compensation and punitive damages pursuant to 42 U.S.C. sections 1983 and 1988. Now, so Mr. Sakuna sued Officer Andruski under two federal laws. Under Section 1983, Civil Action for Deprivation of Rights, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or the person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Section 1983 provides for people to file a civil case against anyone who, under color of law, deprives them of a right protected by the Constitution or laws of the United States. In the case of Section 1988, it appears to be more about collecting attorneys and expert fees. On December 31, 2020, Andruski moved for partial summary judgment under Federal Rule of Civil Procedures 56A, arguing that his actions were justified because he had reasonable suspicion and probable cause, or alternatively, that he was entitled to qualified immunity as to the claims asserted against him because if any rights were violated, they were not clearly established. Officer Andruski asked for the district court to dismiss the case because, he argued, he was entitled to qualified immunity because he had reasonable suspicion and probable cause to treat Mr. Sakuna as he had. On August 6, 2021, the district court granted Andruski's motion for summary judgment in part and denied it in part. The district court granted Andruski's motion for summary judgment with regards to the initial stop. It concluded that since Andruski's basis for stopping Sakuna's vehicle was that the car was stopped at night in the roadway with the engine running in an area known for drugs and prostitution, it was reasonable for Andruski to believe that Sakuna was committing a traffic violation, giving him reasonable suspicion to stop Sakuna and check his driver's license and require him to step out of the car. If an officer sees a car stopped on the side of the road, especially in a part of town known for crime, is it reasonable to stop and ask the driver for his license? Yes. I'm not sure about having him step out of his car, though, but if the officer had simply patted Mr. Sakuna down, I doubt this case would have been filed. After all, Sakuna did hand over his license when asked, and even told Officer Andruski he was carrying. But what about the rest of the stop? However, the district court denied summary judgment on the remaining issues related to handcuffing and detaining Sakuna in the police car, searching the interior of Sakuna's car, and searching the car's trunk. The district court, however, was not willing to let Officer Andruski off on the search and seizure. The district court reasoned that Andruski did not possess the requisite arguable probable cause to justify this conduct, explaining that a reasonable officer would not believe that Sakuna was committing a crime or possessed a meaningful threat of being armed and dangerous for merely disclosing the presence of a firearm and its accompanying permit. That was especially true in light of Sakuna's compliant and non-threatening behavior, and the absence of any articulable reason for defendant to believe the gun permit was counterfeit or otherwise invalid. Guess what? Legally possessing a firearm is not probable cause that you're armed and dangerous or that you are committing a crime. Remember, when Officer Andruski asked another officer, "What should I write him up for?" that should be a clue that you do not have probable cause that someone was committing a crime before you violated his rights. The district court pointed out just how absurd Andruski's claim was. The district court concluded that any contrary holding would make it practically impossible for the lawful owner of a firearm to maintain a Fourth Amendment right to privacy in his or her automobile. Accordingly, the district court determined that Andruski was not entitled to qualified immunity on these issues, and thus denied Andruski's motion for summary judgment in the remaining part. Not surprisingly, Officer Andruski appealed the court's decision.